Hi, I'm Andrew Bradley, and I'm going to talk about the 7 reasons that you should consider getting a shareholders agreement if you're a shareholder of a limited company. The first reason is that company law is generally not sufficient for a small limited company because it doesn't deal with restrictions on transfer of shares. Also, company law doesn't deal with the day-to-day operation of the company, only the main legal elements. So you need some rules as to how your company is going to be operated. The second reason to have a shareholders agreement is therefore about decision making. What percentage of shareholders is required to make certain decisions? Can a majority shareholder commit the company to a loan? Can a majority shareholder force a dividend payment? Those things need to be discussed and agreed between the shareholders and set out in stone. There are 30 of those things that you need to consider. Third reason to have a shareholders agreement is dealing with death. The default position in law is that a party is free on their death to leave their shares to anyone, which means you may have someone involved in the business that you don't want to be involved. On that basis, the shareholders agreement will set out the rules and provisions that apply on the death of a shareholder and generally look to get fair value for the shares back to the estate of the person who's passed away, but meaning that the existing directors don't have to work with the deceased estate. Another matter frequently dealt with in the shareholders agreement is illness. What happens if someone's not able to work or contribute to the business? Would there be a mechanism which would deliver fair value back to that person? That's something that our clients often consider doing. The fifth reason to have a shareholders agreement is all about exit. So as we've talked about, in general terms, you can transfer your shares to anybody if you hold shares. But generally what you want is what's called preemption provisions, which means that if you want to transfer your shares, you have to offer them to the other shareholders first. The shareholders agreement will set out how this works and also may include provisions such as an absolute prohibition on sale to anybody who the other parties don't wish to enter the company. Another issue we frequently deal with in the shareholders agreement is what's called drag and tag rights. So that's basically where a majority shareholder can force a minority shareholder to sell if they want to sell the whole business, or tag where a minority shareholder is able to tag along to a sale by a majority shareholder. Both of these are really important provisions that need to be discussed and agreed as soon as possible. And finally, number 7 is disputes and deadlock. Deadlock, of course, particularly relevant where you have two 50-50 shareholders. So the shareholders agreement will set out mechanisms to deal with disputes in a sensible way and provisions to resolve issues that otherwise may cause significant damage to a business. I hope you found this note helpful. If you'd like any further information on drafting a shareholders agreement, please feel free to give us a call on the following number. Thank you.